the last segment of this, which is the succession law implications. Here we have Akira passing away whilst resident in Thailand, but remaining domiciled and citizen of Japan. And the questions are, with respect to the Thai property, what is the applicable succession law, in terms of Thai immovable property, applicable law with respect to Thai movable property, and then sort of application of Japanese forced heirship. So would Thailand recognize Japanese forced heirship rules insofar as the Thai property is concerned? So if you could help us with this, Kunchinavat.
Yes, in case of the Thai succession law, in case of the foreigner own the immovable property, in this case, I understand it's a condominium. Condominium. And under Thai law, the foreigner can own the condominium in Thailand, not over 49% of the total areas of such condominium. And in case of the estate, asset are the condominium, the Thai court will consider the Thai law because under the rule of the property situation in Thailand. In case for another issue, second question, movable property, the Thai court under the conflict of law will consider the domicile of the dead person. In this case, Akira-san is a domicile in Thailand and his principal resident in Thailand at the time of death. At the time of death, then the court will adopt the Thai law to take care of this case. In case of movable property, for example, cash, share in Thailand, investment in Thailand, portfolio in Thailand.
Right, and insofar as the Japanese forced heirship rules, they would have no application in Thailand. From what they would be enforceable in Thailand. The Japanese forced heirship rules under their succession law, because from what you're saying, only Thai succession law will apply.
Yep.
Got it. Okay. Okay. So insofar as the Japanese property is concerned, what is the applicable succession law to the land, the immovable property? What would be the succession law for the movable assets? And then the application of forced heirship rights. And then finally on the Thai-Japanese tax implications. So which law would effectively the Japanese courts apply for the succession? Would they apply Thai law because of the residency, or would they apply Japanese law? Which would be the case?
Yeah, from Japanese perspective, Japanese law will apply because Akira-san is a Japanese citizen and he is a Japanese national. They have Japanese nationalities. So that's why, all the assets, including immovable property and movable property, will be subject to Japanese succession law. Right. And also Japanese forced heir rights will also apply. Kin-san is a wife of Akira-san, so that's why she has a 25% legal right. And also Atsuko-san is the only child of the Akira-san, Kin-san, so that's why Atsuko-san has also 25% legal right under the Japanese law.
Right, and then looking at the tax implications, because both Thailand and Japan have inheritance taxes, how is this going to play out in terms of double taxation potentially?
Under the Japanese inheritance tax law, all the properties, including the Japanese properties and the foreign properties, will be basically subject to Japanese inheritance tax. But if Akira-san and his families continue to live outside Japan for more than 10 years, only Japanese assets will be taxable. In that case, foreign assets will not be taxable.
Right.
Okay.
How would it apply for Thai purposes, the Thai inheritance tax?
Yes, Zach. In terms of the Thai inheritance tax, Akira is a person who reside and stay in Thailand. It can be said that Akira is a resident in Thailand and subject to Thai inheritance tax for the asset in Thailand and for the asset outside Thailand. This is similar to Japanese inheritance tax law.
And presumably there's going to be some level of relief at the tax authority level, that they will grant some level of credit for taxes paid.
Yes, yes.
Right, okay. Okay, and I think in terms of the Singapore Trust, whether Japanese forced airship claims can be made against the trust. So looking at the case of Kin and Itsuko, and how would Singapore react to a potential attack on the trust from a forced air? So I guess the first question is it possible or is it common for Japanese heirs to make claims against foreign assets held in trusts if it in some way infringes their forced airship rights?
Yeah, in Japan, it sometimes happens. So, you know, Japanese forced air crime is very strict under the Japanese law. So that's why sometimes some heirs argue that they have some legal rights under the Japanese law. But in Singapore, maybe Singapore government or Singapore court may not accept such treatment. That is my understanding.
Yeah, that's correct. So from a Singapore standpoint, Singapore does have within its laws a anti-forced airship provision, which would seek to defeat any sort of claim made on the basis of succession or inheritance. So it wouldn't be a claim that would necessarily be recognized in Singapore if it were brought by Kin and Itsuko.